And I think we've got people coming in, so we'll kick it off. Welcome everyone. My name is Kyle Kroll, and I'm a shareholder here at Winthrop and Weinstein. And we're so happy that you could all join us today to talk about 5 ways that you can save $1 million or more in 2023. We'll certainly have some examples of where the amount at issue could be more than $1 million. I'm very pleased to be joined today by some of my colleagues who I will introduce to you very briefly here. There's so much that could be said about all of them, but I'll give you just a little rundown of their areas of practice, and then we'll jump right into the information that you all came to hear. First, we're joined here on Zoom by Matthew Robinson, who is another shareholder here at Winthrop and Weinstein. He is in our business litigation group, practices in the areas of securities litigation, employment litigation, insurance litigation. He will provide a large variety of perspectives today from his practice. We're also joined in the room with me here by Noreen Sedgman. Noreen is the chair of our corporate and transactions practice group. She works with closely held businesses and corporations. She does work in M&A, due diligence, corporate advising, and the list goes on. Welcome, Noreen.
Thank you.
And also joined today by Chris Hussey, who is also in our corporate group. Chris, actually, prior to becoming an attorney, worked in corporate finance and brings all of that to his work today as an attorney working on M&A deals, securities, private equity, transactions, and more. So welcome, Chris.
Thank you, Kyle.
Also for attendees today, if you have a question throughout the presentation, we do have a Q&A feature. It should be available to you through the Zoom platform. If you have a question, please submit it. I'll be trying to watch for those questions, and we'll try to answer them as best we can. We also have some time reserved at the end to take up any questions. And if we don't get to your question today, we'll try to follow up via email as well. All right, so why don't we have some slides to share with you throughout the presentation today. Put those up. All right. Now, we have put this presentation together based on our experience in representing businesses for several years now, as well as research and what we're seeing in the market that are trends, that are areas of growing risk or concern that business people really ought to be thinking about more than in the past going into this new year. And we've identified 5 areas based on that research. And each of these we think is an area where if you're diligent and proactive, you could actually save $1 million or more in this year and maybe even into the future. So without further ado, we're going to jump right into it. The very first of these topics we think is a growing area of risk and concern for businesses is confidentiality clauses and non-disclosure agreements. Many of you may have heard that the FTC has been considering banning confidentiality clauses, or excuse me, non-compete clauses in employment agreements and other kind of employment settings. And states such as Minnesota are also considering the same. And I think I even read today that the National Labor Relations Board has taken a pretty strict view on these as of late. In addition to this kind of new legal development, we're also seeing, of course, increased employee mobility in a really tight labor market. And so business people and businesses are, I think, going to see these two kind of trends collide, because if you can't enforce a non-compete for your executives or key employees at your business, and you have legitimate concerns maybe about confidentiality or trade secrets or whatever you're working on, then you're going to have to turn to a different area of law. And you might see this more because you might have employees moving around a little bit more. And you might be onboarding people. So this is an area to be thinking about as you are onboarding new employees. Where we think that the growth will be is in confidentiality agreements and non-disclosure agreements. These types of agreements are ways in which you can protect the very sensitive business information at your company. It could range from customer lists to projects that are under development that you don't want competitors to know about, to special information about partnerships you have, and the list goes on. It could be inventions. And so we think that this is going to be where the main enforcement area, where the area of enforcement is going to be. Businesses are going to have to turn to their confidentiality agreements and non-disclosure agreements to, if they have any hope of trying to protect against what might seem like unfair competition if an employee were to leave. Now, we have an example of how this can play out for discussion today. There was a recent case in California. The company had an executive, highly paid, multi-year type contract, and in a very sensitive role. The company, I think, wanting to protect itself as much as it could, had entered into a broad confidentiality clause with that executive, saying, any information that you know about equities or securities trading of any kind, or really anything in the securities realm, was covered. You had to keep all that confidential. You couldn't use it at a future employer, whether or not they were in the same business, which happened to be equities trading. So, for example, if this executive had gone to a competitor that just traded a different kind of securities, it would still apply, and it would still greatly restrict that employee or that executive's ability to work at that new business. So, what happened is the executive decided to go to a competitor in the securities trading space, and the employer, of course, sued, and there were allegations of damages that were 1.5 million or more. The problem, unfortunately, for the business was that the clause was so broad that it was effectively a non-compete. And this, I think, provides us some insight as to how courts across the country are going to look at this if non-competes are banned generally, because California already bans non-competes. But they look at confidentiality clauses as well, and to determine if they're effectively a non-compete. And the court said it was, because it was just so broad. So, of course, the obvious takeaway from a case like this is that while it might seem like the best course to have a broad clause, it could actually undermine your ability to enforce it at all. And so you might need to be a little more tailored. So I guess I throw it over to my corporate friends here, where they see these things come up a lot. What are some additional insights that you have or you're seeing in this space going into the new year?
Well, you should distinguish between what Kyle just discussed, which is non-competes in employment context, versus a non-compete in just a regular business-to-business commercial contract context. The FTC rule, I believe, is not directed towards those types of non-competes. So if you are a business and you want to enter into an exclusive relationship with another business, you'll probably be permitted to do so. Again, you're going to have a lot of similar issues of making sure that non-compete is tailored and appropriately protects everybody's different interests. And then notably, the FTC rule, and I would expect any other state similar rules, are exempting non-competes in the context of a business sale. Non-competes in a business sale are very commonly applied to the seller. It seems there's some smart person at the FTC concluded that banning non-competes in a business sale would have a big chilling effect on the M&A market if the seller could take $10 million of proceeds and turn around and compete against the buyer.
And I'd say a few other takeaways from my perspective really is that there's this heightened focus on the importance of confidentiality covenants. I think that means that the onus is on all of us to make sure that the confidentiality restrictions we do have in place are very well drafted. A few of the key terms that I'm always making sure are in my confidentiality restrictive covenants include severability and blue pencil provisions. Those address some of the concerns that Kyle was raising about, perhaps an overbroad confidentiality provision being interpreted as a functional non-compete, this at least gives the party trying to protect their confidential information additional arguments that instead of just striking the language entirely, a court should work to reform it and interpret it in at least as liberal a fashion as the court is willing to interpret it. So I think those are nice kind of backstop provisions or protections to be putting in place and, have as sort of, backdoor arguments if you lose on your initial argument. I think another key term that I'm putting regularly in my restrictive covenants is a carve out for trade secrets. Oftentimes there is a specific term of a confidentiality covenant. You might say it's a 3-year term. And that represents the general understanding of how long a lot of business information really remains sensitive and really needs that confidentiality protection. However, with trade secrets, it's really important to include a carve out there where that would survive indefinitely to avoid any sort of argument that trade secrets are waived or that they're becoming accessible to a larger public. So I think those would be the top takeaways from my perspective, just as as all of you think about negotiating and drafting confidentiality clauses.
The only other thing I'll add is consider at the heart of the matter is, particularly in the employment context, is you are dealing with a person. The person has a family. They're coming to work for you. So, consider that when you're having someone draft, in particular, a non-compete clause and how that might come over to the employee and how you are the type of foot you're getting off to with that employee if you deliver them something that's excessively overbroad, very heavy-handed. That's going to telegraph something to that employee versus if you can put something that's very tailored, supportable, defensible, that employee is probably going to have a little bit better perspective about walking into that type of employment context than something that's very heavy-handed and frankly aggressive or just inappropriate.
Well, and I think what you're saying there, Chris, about how the employee perceives it kind of goes to what the court was concerned about in that California case, which is it meeting kind of the reasonable expectation of the parties when they're negotiating this? And if it had been focused on just equities or maybe even pulled out certain things, even if they might have implicated securities, it might have been enforceable and they might have still had some protection in that area. And the employee would probably have understood that too.
Right. Yeah. If you're going to work for a big medical device company and you're going to have a non-compete, your reasonable expectation is probably going to be restricted from working for other medical device companies, not like a franchisee of a sandwich shop.
Right. One of the things that you mentioned, Noreen, in your remarks was something called blue pencil. And I know we may not have attorneys on the line and maybe haven't heard of blue pencil. Could you explain what that means and what you're referring to in terms of what should be in the confidentiality clause?
No, absolutely. That's a great question, Cal. Thanks for asking. So, blue pencil basically is a specific contractual authorization for a court if the court finds a provision to be overbroad, overbearing, unreasonable, if you will, instead of just striking that clause or instead of just striking saying they won't enforce the entire agreement. This provision directs the court to reform it in the way typically that will make it enforceable to the greatest extent that a court finds it to be reasonable. So it basically gives the court license to rewrite your contract, if we will, which I think from the party standpoint that's trying to enforce these restrictions is much better than just having it struck.
Absolutely. This also kind of reminds me of another takeaway, but because of what you had also said, Noreen, about trade secrets. And it reminds me of a case that we had recently where we had a very successful result in a trade secret case. And it implicated these kinds of confidentiality concerns because it was a similar kind of like the California case, an executive who was really running an entire branch of this client's business went off to form his own competing business. And of course, there was a non-compete issue, but there was also confidentiality and trade secret issues. And one of the things that was so helpful to that case as an attorney in working with the client's business was that client had a great tech team internally at the business, an IT team that was able to we were able to work with them to put together a little report on what information this executive took with him and how he had tried to even cover his tracks. And You know, businesses should be thinking, I think, a little bit about that, and ensuring that when you have a case like this, you're connecting up the relevant tech people with the attorneys so that they can put something together like that to really prove the case. That's just something I have been thinking about, and I remember working on. It was also it's a lot of fun. Well, any other takeaways? I mean, I think this is gonna be what we're gonna see on in terms of litigation about a movement of executives if non-competes are banned. This is really where it's going to be.
I guess one other thing that, just kind of jumps out to me from this discussion is really that we should all be paying more attention to the confidentiality clauses in our restrictive covenant agreements with employees, because if, say, the FTC or Minnesota bans non-competes, those confidentiality clauses really take on a heightened importance. So I think it merits additional time and thought spent on those.
Absolutely. All right, well, let's move on to the second way you could save $1 million or more in 2013. I'm going to hand this off to my colleague, Matthew.
All right, thank you all. And that's a great transition, Noreen, talking about the increased importance of confidentiality provisions given the shift. And I think the last takeaway you talked about is, don't treat it as boilerplate. Make sure you're paying attention to them and make sure you're using them to your advantage. And our takeaway here is going to be almost the same thing for indemnification provisions. Don't treat them as boilerplate. Be very intentional about them and really take advantage of the extraordinary amount of flexibility the law gives you in fashioning an indemnification provision to better position your business. So as we all know, indemnification at its most basic is shifting liability from one party to another. Indemnification provisions are used in all sorts of commercial contracts, just about every sale of a business contract, and any number of things in between. We're not going to talk about this today, but there's common law indemnification, statutory indemnification, and it can come up in a whole host of different methods. In commercial contracts and M&A deals, indemnification provisions are more and more popular. You really, as I mentioned, probably don't see sale of business agreements without indemnification provisions. We're seeing more and more both general indemnities, but also standalone indemnities. So you're doing a deal, something unusual comes up in diligence, and instead of blowing up the deal or having it negatively impact the purchase price, you can create a standalone indemnity that basically says, I will have no liability for this whatsoever, this very specific item, if it comes to be, based on what I've seen, is going to be something you're taking care of. So with this increased amount of indemnification provisions, both contractual and statutory and all that, of course, we're seeing more litigation surrounding indemnification. And when we look at the litigation from the litigation perspective for Kyle and I, an indemnification provision in a contract is a contract. And so our courts are going to look at the four corners of the contract, and they are going to typically, and I say typically because there are a lot of caveats, but typically enforce the plain and unambiguous language that's set forth in the agreements. And so for that reason, the two examples I'm going to give before I hand it over to our corporate colleagues to talk about really talk about the importance of words. And that's specifically true in contractual phrases, but all the time. So the first one I'm going to talk about is negligence. And so there is a recent case, and it was a big 7-figure case. And the indemnifying party, I should say the party seeking indemnification, was seeking indemnification for a loss that was caused in part due to its own negligence. So to use example, my company is negligent in part, and I caused this loss, but I have this contract with an indemnifying party, and I say, hey, there was this huge loss. Ignore the fact that it was partially my fault. I need you to cover that for me. And despite the fact that common sense would dictate otherwise, and perhaps the intent of the party, the indemnifying party, didn't think that would come into play, the court looked at the agreement and said, well, it says right here, the plain, express, unambiguous language of this indemnification provision provides for indemnification even where the indemnified party's own negligence contributes to the loss. In contrast, had the provision not said that in Minnesota and beyond, but check with the jurisdiction, the general rule is that negligence would not be covered. Strict scrutiny is applied, and unless the provision does specifically say that it covers the indemnified party's own negligence, typically it won't be. So it's just a really good example of, going into crafting these indemnification provisions on the front end. If you are the indemnifying party, you probably don't want the indemnified party's negligence to create a loss that you have to cover. So make sure the contract doesn't say that. On the flip side, if you are a party, you're in an industry or a sector where your own negligence may contribute to a loss that you do want to be indemnified, make sure your provision says that. Really just break it down, and again, as I mentioned, this incredible amount of flexibility to have the indemnification cover what you want it to cover, not cover what you don't want it to cover. And I think Noreen will talk more about this, but different indemnified parties, whether you want it to hit against escrow, whether you want to decrease a seller note, any number of things you can craft. But from the litigation perspective, to pass scrutiny and to enforce what you actually want to happen, it's got to say that pretty clearly. The next one, and this is one of my favorite cases, there's a recent case, and it really came down to, and when I say favorite cases, us litigators will get in entire cases about just a word or two. And so these nexus phrases in indemnifications pretty much mean the indemnifying party will indemnify for a loss, fill in the blank nexus phrase, related to, resulting from, caused by X. And when you're crafting these agreements on the front end, those three nexus phrases I just mentioned are all pretty similar. Caused by, related to, resulting from. Let's pick one randomly. Let's use what we used in the last deal. Don't do that. Think about it. And so there's an entire case where there's this gigantic loss, again, a big 7-figure loss, and the contractor is seeking indemnification from the subcontractor. The whole case is whether or not the loss was, quote, caused by the subcontractor's work. And as you read through the case and you read through the facts, the court ultimately holds that the loss was not caused by the subcontractor's work for a variety of reasons we don't really need to get into. And ultimately, there was no indemnification that was triggered. There's some dicta in the case that talks about it, and kind of as you read through the facts, you see, had the nexus phrase been related to, or maybe even resulting from, the court's conclusion probably would have been different, and they probably would have held that the loss was related to the subcontractor's work, even though it wasn't caused by. So what does that mean? So it's an interesting example. Contractor thought they had protection, thought they were mitigating their risk, thought they had coverage for these types of things, and it ended up they didn't, right? And it's probably because they just didn't put enough thought on the front end into that nexus phrase. So we see indemnified parties, the parties seeking indemnification, using broad phrases like related to, because it increases the scope of the indemnification. And we typically see the indemnifying party wanting it to be more narrow, caused by, things like that. So that's just two quick examples of big $1 million verdicts that really came down to the very specific meeting. And I'll toss it over to Noreen to talk a little bit more about indemnification provisions on the corporate side.
Thank you, Matthew. So I think, one of the things that really stands out to me about indemnification provisions is they allow really an extraordinary number of different opportunities for skillful negotiation. And the way I look at it is, it's almost, when you're negotiating an indemnification provision, you have a whole kind of series of levers or, different elements of that provision that you can focus on or negotiate to try to get the result that, you would want to get, depending on whether you anticipate you're more likely to be on the indemnifying side or the indemnified side. So, some examples just that, I'm consistently thinking about and negotiating on the transactions I work on. The issues include things like the definition of indemnifiable losses. Are these just direct damages? Does it include consequential damages? What about punitive damages? There are all sorts of categories of, losses that either can be specifically excluded from indemnification or, affirmatively included. And those can have very significant, different results depending on how that term is used. Another example, and this I would say most commonly comes into play in, acquisition agreements, although, these concepts can apply in commercial contracts as well. The concept of a cap or a basket, or, sometimes it's called a deductible in connection with indemnification. And what that means is you can specifically negotiate that the indemnification will be up to a certain dollar threshold, or that, there has to be at least a certain threshold of damages that need to be reached. Think of it like a deductible under an insurance policy before the indemnification obligations of the indemnifying party kick in. Both of those, I see really those are key risk shifting provisions that in a way make the indemnification provision more like an insurance policy, which I think is one way to think of indemnification provisions, is this is contractually negotiated insurance between two parties. A few other key provisions that I'm looking at critically when I'm negotiating these would be the categories of persons who are able to bring indemnification claims. Sometimes that's different than just the parties to a contract. It may be certain, successors to those parties, affiliates, in which case you may also want to modify the clauses, say in the miscellaneous section, to make sure that there are those are third party beneficiaries that can enforce those contractual provisions. You can also think about adding provisions about an affirmative duty to mitigate for the party that's seeking the indemnification, that, before they can just turn around and pursue an indemnification claim, they need to take reasonable steps to try to limit their losses. And that at a minimum, if you're providing the indemnification, gives you something to argue about if it turns into litigation as to whether or not they properly mitigated their losses. A few other terms that I think are worth considering is, to the extent there's third-party insurance, do you want to contractually provide that there's an obligation to pursue that insurance? And if the indemnified party obtains insurance proceeds, should they have to offset those insurance proceeds against what would otherwise be their indemnification claim? And then I think another key item that comes up on almost all of these is, what are the procedures for indemnification? Does the indemnifying party have a right to control the defense of the indemnification? That can help enormously in terms of having the opportunity to select counsel that you trust, that will vigorously represent the interests, and that's you think is someone you're comfortable with, especially if you're paying all the defense costs as the indemnifying party. On the flip of that, if you anticipate being the indemnified party, you may not want the other party to be able to fully control the defense. And so there are also opportunities to negotiate various, carve-backs or situations where you might say, well, in this specific instance, I actually want to be able to control the indemnification. Maybe this could be, for instance, in the case where the party, pursuing the suit there's a third-party claim seeking injunctive relief, where you might say, in this specific instance, I as the indemnified party want my own counsel representing me, and I'd just like the indemnifying party to, pay the legal bills. All of these things, can be negotiated on the front end. And I think what I would really echo that Matthew, emphasized in his initial remarks is just this is not a one-size-fits-all clause. And I think you're really making a mistake if you just automatically pull an indemnification clause from another contract that maybe worked there without thinking critically about the various components of it and how in this specific different situation what sort of specific additional terms you might or might not want to include in light of that.
Mhm.
Noreen made a good distinction between indemnity clauses and acquisition and sale agreements, where you're going to have, assuming the lawyers on each side, it's not their first time on a deal, they're all going to be heavily focused. It's the principal area of risk allocation when someone's buying a business. But you'll also see indemnity provisions in standard commercial contracts of any sort. And there's just a huge number of clauses floating around in the world that you're going to get put in front of you. So if you're the typical posture is a buyer is going to want the broadest indemnity possible with nearly no limitations, and the seller is going to want something more narrowly tailored or no indemnification at all. And so there's always that tension in just a general commercial context of how much do you or how much can you negotiate an indemnity clause? If you're a seller of a product or a service to a Fortune 500, most instances that Fortune 500 is going to be putting their contract paper in front of you. And I would, 9 times out of 10, it's going to include some sort of an indemnity provision. That indemnity provision is going to probably have no limitations on it whatsoever. So as the seller of the product, how much do you want to try and push that buyer to include, some sort of limitations that have some sense of proportionality for what you're doing for them? If you're just selling them $5,000 worth of widgets, should you really be providing unlimited indemnification akin to basically a complete insurance policy? Probably not. If you're, building $50 million worth of equipment that could cause serious personal injury, you'll probably as a seller want some sort of limitations, but the buyer is going to be a lot less willing to take those types of limitations given the type of risk that they'll be shouldering as they use your product. So there's always that tension. And of course, as a seller, most often you're going to want to get the sale. And so you're not going to want to do a whole lot to the contract. You'd probably just like to sign it. But there is that tension of, considering the proportionality of what you're doing for whoever your customer is, and then acting accordingly. Like I said, if it's $5,000 worth of sales, you can probably let it go. If it's 50 million and it's some risky endeavors, you're really going to want to try and negotiate and limit and tailor any type of an indemnification provision.
Good points. Thank you both. And I think as Matthew's examples show, the trends and the research show that this type of litigation is increasing. For whatever reason, breach of contract cases in general, including these types of cases, are on the rise. And a recent report that I saw said that plaintiffs in those cases tend to win their cases about 70% of the time, which is really high. I mean, maybe that's a good thing if you're depending on what side you're on. But this is a growing area of, I think, concern and risk for businesses going forward. Let's head on to our third topic for today, and that is kind of related to what Chris was just talking about, deals, and in particular, deal insurance. Sometimes it's called R&W or W&I insurance. That stands for representations and warranties insurance and warranty and indemnity insurance. It can go by many different names, but it's insurance that is procured usually by a buyer, but it could be both sides in different contexts for the deal. And it's usually procured so that the buyer has some kind of backstop, some way to recover if the buyer finds out that the seller didn't quite disclose everything or tell the whole story or provide accurate information to the buyer about what the buyer was buying, some business unit or some company or something along those lines. But what we've seen is that R&W and W&I insurance, while for a long time used to be for really, really, really large transactions of like 100 million or more in terms of the enterprise value at issue, now is being offered and written for transactions that are much smaller. I think even into just single-digit millions, and we'll talk a little bit about that. But this is a growing area, and more insurers are willing to provide some insurance for buyers in this area. And one of the things that, as this has kind of expanded in terms of popularity and its use, is insurance companies are seeing that they have growth areas in the types of claims that people are making under these policies, the types of false statements or false representations or failure to comply with warranties that lead to the buyers to try to obtain some coverage under these policies. And that is in two particular areas: material contract breach and compliance with laws. Material contracts, as our little diagram here that has some information from AIG shows, are about these really important contracts that the whatever business you're buying has. It's usually a customer relationship of some kind, and really the representation usually is something to the effect of, we're not in breach of any of our material contracts. So if if the business you're buying has 50% of its revenue come from one customer, then that's a material contract, no doubt. And you, as a buyer, you want to make sure there's nothing wrong with that relationship, because you're buying the value of that relationship and hope it will continue. Some of the ways in which there have been claims of breaches of these material contracts and breach of the representation about those material contracts are about the profitability of that contract. So if the seller lies about just how much money the business you're buying actually makes from a contract, that's the number one category. But the other one is just plain old breach. You're behind on something, or you're not complying with it. The other side, the customer has even told you maybe that you're in breach or default. And there are a couple other categories as well. And then it shouldn't surprise anyone that compliance with laws is another area of growth. More and more, of course, there's regulation in industry, and more and more there's sophisticated businesses and startups in areas where there's a lot of regulation, whether it's, as Chris was referring to earlier, healthcare, medical devices, those are areas where there's a lot of growth. And as a result, there's more activity in this space, and there's more concerns about whether you're really in the business you're buying is in compliance with all the laws that apply to it. And for some businesses, that's a lot. That's a lot to be in compliance with. So I guess we shouldn't be surprised that there are people saying that they're not in compliance, seeking for some kind of coverage under these policies. So we have an example for you of a recent case. It actually involves it involves a Minnesota company, a fairly large one that you've definitely heard of. But this manufacturing company purchased a business unit from a competitor, and the seller represented that there weren't any material breaches of any material contracts. But when the buyer got the business and started to see, the insides, realized that one of the largest contracts for that business was actually behind schedule, and it was in the red already. Of course, the buyer was upset about this, and had obtained R&W coverage for this transaction, and did obtain ultimately coverage of $1 million or more. And these types of cases are just coming up more and more and more. One of the things that this business did well, the buyer did well to obtain the coverage that it did, was it really took a proactive approach and a really in-depth, deep dive into the facts to try to make out the best case possible with this insurance company to lead to a good result quicker than it would have otherwise. Interviewing employees, collecting documents, and then piecing it all together. And that is the key to success if you want a quick resolution with your insurance company. But I want to turn it over to our corporate folks to kind of share some of their thoughts about what they're seeing in trends in R&W and W&I.
Yeah, so it's a good point that Kyle made earlier about, initially when the product was introduced, I think probably around 2011, 2010, something like that. It was for larger deals, and it was just starting to get used. In the last, say, 5 years or something, ballpark it, that size has gone way, way down. There's more claims information. Insurers are getting more comfortable with smaller deals. They're allocating more of their risk portfolio to those deals. We're seeing deals of $20 million, which is pretty well in the lower middle market, get coverage. Some of the trends we are seeing might bear on how active the M&A market is. 2020, the end of 2020, there was a high degree of activity. I think some level of concern on tax changes in 2021 that never materialized, but insurers they had their pick of the litter. So they were picking the least risky deals that they thought for underwriting, deals that were heavily regulated, or deals in fields that were heavily regulated were pretty tossed by the wayside, at least with some insurers. We had a very large healthcare deal that could not get insured despite being a remarkably clean company within its field. Pretty much every insurer passed on it due to how much regulation it was subject to and the risk of potential Medicare reimbursement type of claims. So that's one big trend. Noreen, any others that you're seeing?
I think a few other thoughts I have is, I think, rep and warranty insurance, when used best, I think it can really help bridge the gap in negotiations. While it puts more onus on the buyer up front to do due diligence, put together some sort of a due diligence memo to share with the insurance company to show, the buyer actually has done what they can to confirm that the representations and warranties that are being insured are true and correct, again, to the extent ascertainable. But it can make a really big difference on deals. Where I see the biggest opportunity would be, for instance, if the seller is going to stay involved with the business post-closing, maybe the seller is rolling a certain portion of the equity in the business, and maybe some key executives from the seller's team are going to remain as executives on the buyer's team. There's an enormous opportunity here to, if there is a problem, the buyer can pursue a claim against an insurance policy and an insurance company, with maybe some small amount of the claim kind of coming out of an escrow or something from the seller, rather than having a big, ugly, litigation matter that could completely sour the relationship between the buyer and seller. So I think that's one of the biggest opportunities. The other biggest opportunity is, for sellers that really want to liquidate and distribute their assets quickly post-closing. This gives a tool to do that while still leaving a source of recovery for the buyer, to get the buyer comfortable that post-closing, if there is a problem that comes up, it's not that risk isn't falling entirely on the buyer. So, where I see representation and warranty insurance being most useful is really helping kind of address certain risks or contingent liabilities in a way that perhaps is more amicable between buyer and seller. And just, again, I think one of the themes you'll see from this entire discussion is just adding flexibility. So, if you're working on a transaction, just consider this one of the potential options that you might have to add flexibility as you, negotiate the key terms.
Yeah, well, while you might think adding a sophisticated third party to the mix creates complications, at this point, for attorneys and their deal teams, in particular attorneys who are pretty much bringing the deal to the finish line, who are familiar with the product, it really does not add a lot of deal friction. Like Noreen said, there's a little bit of extra work on the buyer's side. Seller might need to be a little bit more thoughtful about how they provide diligence. There's some timing considerations, but for the most part, it frankly can end up streamlining things. And as Noreen mentioned, can make the process of risk allocation a little bit more amicable between the buyer and the seller, because they're pushing all of the risk or the lion's share of the risk onto the insurer, who's a third party and plays the role of, insurer very, very well.
Well, and you were saying maybe it might be perceived as adding deal friction, but it sounds like it can also be a deal lubricant in some ways too. So there are opportunities
absolutely.
here.
Probably more of a lubricant than friction at this point. So long as the buyer and seller are comfortable with the added cost for the premium and the broker fees, which funds they don't get back, and in particular for a seller, if they're just thinking about basically providing self-insurance without the third-party insurance, they might get all of that money back without having to pay any type of premium for an insurance policy. And depending on what that premium is, they might say, well, I'm going to take that risk because I don't want to pay $500,000 for an insurance when I think I've got an incredibly clean company.
All right, moving along now to our fourth topic, Matthew.
Absolutely. So the fourth topic we're going to talk about today here is insurance, retentions, and deductibles. And what we're focusing on this afternoon is really the increase in the inflation in the retentions and deductibles that we're seeing. One interesting fact that sort of jumped off the page to us is that last year, more than 70% of the claims were for losses that were entirely within the retention amount. And that can be a big problem for a company. I would ask, I think our corporate folks are going to talk about, for those of you who are on this Zoom right now, do you know what insurance policies your companies have? You might know the premiums, but do you know the deductibles and retentions? If your insurance is coming up to be renewed recently and you're working with your broker, a big mistake could be focusing solely on just the premium and not worrying too much about what the retention or deductible can be. And having insurance with too high of a deductible or too high of a retention that doesn't really match your business, your company, your sector, your likely claim can almost be like not having insurance at all. So that's what we're talking about here today. And again, it's just this increasing retentions and deductibles that we're seeing, and largely due to increased costs and inflation. And it's really made it very important to focus more so on, is this retention deductible amount right for me? So one of the cases I'd like to talk about here is a recent case. And there was a buyer of a whey protein business. And they found out after the acquisition that the seller was committing fraud against one of its customers. You fast forward a little bit, and the buyer sues the seller for breach of contract, for fraud, other violations, and the total claim amount was right around $1.5 million. Well, the deductible was right around $1.5 million. And I shouldn't say right around, it was $1.5 million. It goes forward to court, and ultimately the court held that the insurance company did not have to pay. Among other things, fraud wasn't covered, but for purposes of our example, the policy had a $1.5 million self-insured retention, aka deductible. And even if fraud had been covered, the $1.5 million in damages were the seller's responsibilities. and it only would have kicked in for amounts in addition to the 1.5. In this case, this policy actually also had a $10 million cap, which didn't get triggered, but that's something to keep in mind also. And so the reason we're talking about this today, and the reason we're talking about it as a trend coming up, and really a pretty easy way for a company to save money, $1 million or more, as our title suggests, is, again, there's a lot of flexibility in insurance. This is all very highly negotiated. And you're going to be dealing with your insurance company and your broker, again, to make sure that the retention and the deductible is something that makes sense for you. So with that, I'll toss it over to Noreen and Chris to talk about the corporate side.
I think, one key kind of takeaway or suggestion I'd make to the business people on the team is, we find many of our clients have not updated or really reviewed their insurance coverage, really critically and thoughtfully in many years. And this dovetails on a lot of the comments that Matthew's making about, taking a look critically at deductible, retention amounts. Another issue that I think would be worth the people in this webinar considering is just, categories of coverage. And in particular, making sure that you've got, all the different categories for the potential claims your business is at risk for. For an example, a standard general commercial liability policy probably doesn't have coverage for cyber insurance or cybercrime. And that's an area that we're seeing a lot of additional risk and exposure for our clients. So, I think a critical look and an exploration of, what sort of even new risks are coming up and are there new insurance products that can address those, I think is time very well spent the next time your, kind of portfolio of insurance comes up for renewal.
Yeah, I'll add that in some commercial contracting context, I'm seeing insurance requirement limits increase. So historically, in most commercial contracts, you might see a requirement that any seller of product carry, commercial general liability insurance with a policy limit of $1 million or $2 million in aggregate or something like that. I've started to see, and I don't have tons of data for this, it's just more in my own practice, some increase of that general policy limit moving up to $2 million, which is a little scary to think that 2 million is the old 1 million. But in most instances, I think a lot of businesses are going to probably try and carry some sort of, mild bare minimum commercial G&L policy, maybe cover it with like an umbrella overlay. But they're, if you're not carrying that insurance and you've got a contract that says you have to carry 2 million, I mean, you're in breach of that right away. And if there was an issue, that could create, more headaches for you down the road. So there might be benefit here to reviewing your policy limits and frankly, erring on the side of caution and possibly paying more in premium to get more coverage.
Thank you both. Well, I think we'll go right into our last topic. And like I said, please use the Q&A feature if you have any questions. We hopefully will have a little bit of time at the end to answer them. And if we don't get to your question, we will follow up with you as well. All right, last topic, guarantee triggers. So these are going to be more and more, I think, important because we're seeing already, and we likely will see even more and more personal guarantees being required in the context of commercial transactions. I think the reason that we're seeing more personal guarantees as of late has to do with the higher interest rate environment. When you have a higher interest rate, of course, there's a greater risk of default, which means people want some additional, insurance, as we've been talking about, but in the form of a guarantee for whatever it is that they're, whether they're loaning money or they're providing, a long-term commercial lease space or something along those lines. You're going to see more and more personal guarantees. And as a result, guarantee trigger language and an alignment between when the guarantee actually triggers, when a personal liability would start to attach to the actual, whether it's the lease or the note or the loan or the whatever it is, the language in those contracts, alignment between the two is going to be key to enforceability. And in fact, we have seen this in our own practice here. In a recent case, we had a client that owned a large commercial space and had a 10-year restaurant lease. That's a pretty big lease. That's a pretty valuable lease. It's not, it's certainly fair to say it exceeded much more than $1 million. Now, there was a personal guarantee in place for this. This was a new restaurant, entirely new. And the personal guarantee provided that it would be triggered if there was a default under the lease. I'm simplifying things a little bit, but the default under the lease provisions, those included if the restaurant became, quote, insolvent. And the default provisions even seem to say that if there was a default, that the landlord would have to provide some kind of notice to the tenant that they were in default, but it wasn't really clear. I'll disclaim that we did not draft these contracts. We only litigated them. But in this case, the court ultimately held that, fortunately for the landlord, despite that ambiguity about notice, no notice would be required. I mean, after all, how do you provide notice to your tenant that your tenant is insolvent? How would you even know that? So
your tenant is in a better position.
Right,
to ascertain that.
Exactly. So obviously you have to be careful with these types of terms. The court won't always save you, but the court did here. But then the court held that the word insolvent is ambiguous. I think for a lot of people in the business world, that probably is surprising. Well, wait, isn't there an established definition? There actually isn't. There are about 4 or 5 different definitions of insolvent that you can find. There are legal standards, accounting standards. So, of course, that was challenging and threw a wrench into things. But I think this kind of dovetails. Not only is this an example of how guarantees are popping up more and more, but it dovetails with some of what we've been talking about being really specific with language in all of the different areas that we've been discussing today. If the language had been a little bit more refined here and specific and defined, then the alignment between the guarantee trigger and the breach provisions in this lease would have been much clearer, and it would have led to a much more streamlined and simple result for the client. Now I turn it over to my corporate friends. What are you seeing in this space? What should businesses be thinking about when it comes to guarantees?
Well, you talked about specific and thoughtful language. If you're providing a personal guarantee for your own business or for a business you work for, the theme is narrow, tailor it, limit it every single way you can to make it as hard as possible for anyone to come after you and your personal assets to cover on that guarantee. The person or the organization getting the benefit of that guarantee is going to want, obviously the opposite. They're going to want the broadest possible personal guarantee that they can find. And usually you're trying to look for a happy medium. We mostly see personal guarantees in the context of privately held businesses that are closely held by, one or a few shareholders. You see it a lot in the real estate context where a principal developer is providing a personal guarantee on a commercial real estate loan. In either context, businesses should consider, they don't always have to, whether the person providing a personal guarantee should get some form of compensation for doing that. That's very common in the real estate field. If a principal developer is going to provide a personal guarantee for a $30 million real estate development project loan, they should get some type of compensation for that as they're putting their personal assets on the line.
What do you call that, Chris? Is there a name?
A personal guarantee fee, Kyle.
Or a PG fee?
A PG fee.
And if you're able to say, you were just using an example of about $30 million contract and they ask for a personal guarantee on that. What proportion would the fee be? What are you seeing in the market?
It'll, I don't know if there's an actual percentage that you apply to the loan. Usually if it's a $30 million loan, you're probably looking at like a low 6-figure fee.
Wow. Okay.
And I think, the other kind of takeaway, I think, from my perspective, and this will echo, I think, what we've been talking about this whole time is, I think it's a big mistake with a guarantee, as with so many things, just to take kind of a one-size-fits-all approach. What might make sense with a guarantee in one context or on one transaction does not necessarily make sense in another. And there's quite a bit of room to negotiate. I think things to think about would be, some sort of a, limited period for the guarantee to be, to cover, or perhaps, limiting the ability of a lender or, the party that receives benefit of the guarantee to add other liabilities to the guarantee, or a cap on the guarantee. These are the sort of things that if you're the party providing the guarantee, you can ask for, you can think about negotiating. And then obviously, if you're on the other side and you're looking for guarantees, these are the things to sort of be anticipating that, may come up in negotiation. And I think it's good to have just thought about those in advance for purposes of negotiation.
And I think, these will be more and more and more common, just given the greater risks of default in the market generally, especially in the lending space. But I've also seen some trends of kind of a roundabout way. It kind of goes back to our first example about like a de facto non-compete, but a de facto personal guarantee, or maybe you have to provide some kind of loan or pledge of secure, collateral or something like that. And then hidden within there is something like, and also if I'll be responsible for full recourse and making you whole and all of these things. I mean, is that something that that businesses should be, or business people should be wary of, or maybe even thinking about, depending on what position they find themselves
Yeah, I
in?
think in a commercial contracting context, anytime that a buyer is a seller is requesting for any type of buyer or something like that, any type of collateral, that should be scrutinized.
Mhm.
Most of the time, I see it pretty rarely that there's any type of collateral posted. Usually it's a credit check. Maybe they post some advance payment, but business to business type of stuff, you're typically not seeing additional collateral pledged unless, of course, it's some sort of a real estate context or maybe an equipment loan or something like that. But if one business is just selling something to someone else, usually there's no collateral, and if collateral is requested, that should either be rejected out of hand or heavily scrutinized so it's not overbroad.
And I think one thing I would, just share with this group would be the thought, really the purpose of a guarantee, it's a trust mechanism. It's something that's helping kind of bridge a trust gap between two parties where one party has concerns about the ability of another party to perform. And, if you're, say, being asked to provide a guarantee, I would submit there are other trust mechanisms that you could potentially offer in that instance, funds to be escrowed, some type of a bond, something like that. So just things I would say to consider that, both think about kind of what the purpose of that is. And then, there might be other things that, from a personal standpoint, you might be more comfortable with, if that's something that the other party is pushing for.
Well, that does bring us to the end of our presentation today. We've talked about 5 areas of kind of growing risk and concern for business people and some key takeaways for all of them. We thank everyone who is able to join us today for doing so, and hope that you found it helpful and educational in your work. We're happy to answer any questions you have. You can use the Q&A feature. I know one thing that has been on the mind of a lot of businesses, I know we've got a couple minutes, has been supply chain disruption, and whether we have kind of thoughts about that. And I think that kind of goes a little bit to the material contract breach topic that we were talking about earlier on R&W insurance, because of course, your partnership agreements aren't your customer relationships, but you still might have some contracts where you're getting something or providing something, and there could be disruption still from the pandemic. I see it coming into play there, but do you see any kind of increased risk, or is that kind of a risk of the past for businesses going into this year?
I still think, and I get the sense that there's probably some supply chain issues still going on, nowhere near the level of, say, 6 or 8 months ago where it was very acute. But it for my clients that have global supply chains of different types of not just finished goods, but raw materials, they're continuing to see delays, although I don't think it is as acute or problematic as it was, 8 months ago when Chinese ports were closed and there was a backstop at the main Los Angeles port of container ships 15 miles long. But we're probably still going to be living with some supply chain issues and things like that for at least a little while longer.
Yeah, no, I agree. I mean, I think from, discussing with my clients, I think certainly there are continuing supply chain issues, and I think that plays out in a number of different ways. I mean, that also plays out just in terms of inflation and increased prices, as well as there's increased competition, for the same supply of goods. And, I think that also implicates a clause that I know we kicked around as a potential category to discuss on this webinar, but we, decided to favor some of these others, but would be force majeure clauses. And, what happens if, due to circumstances outside of your control, you can't perform on a contract, and, just some of the ways to navigate that. But that's certainly something that, we're discussing with clients as well.
Well, and I think the force majeure clause issue, it's not always litigated in this way, but it just goes back to a point we kept saying all day, which is if you want to protect against something like that, include it.
Mhm.
Be very specific and don't leave things to chance.
Right.
I think you're right that a lot of this is behind us. I was reading somewhere that for the most part, a lot of these courts are fine now and things are kind of figuring themselves out. But certainly it doesn't hurt to be proactive and thinking about, well, it happened a couple of years ago. You never know, it could happen again. Let's start actually including it in the contract so we can prevent costly litigation over the meaning of these terms, maybe. I'm going to cross my fingers that that's not a thing we have to worry about in 2023, though. I think that does bring us to time, and we thank you again so much for joining us, and happy to assist you in any ways that we can going into the future, and wish everyone a good rest of their last day of February.